I see Jackie.
Hi, I'm Debbie Moraes, and this is Legal Matters, the program designed to address some critical issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics, as you know, from finance to family law, social security to workers' compensation, and more. Today we have a timely topic, technology and the law. As you know, technology advances at breakneck speed, logically the law not so. That fact poses some very interesting questions for us to explore today, and hopefully you'll find some useful information for both businesses and consumers. So, I think before we begin, we should follow up on our last topic on elder care law, and with us again we have Jackie Grasso and David Bizar from Audette Bizar Cordero Grasso Law Firm in East Providence. Again, thank you.
You're welcome.
Okay, so the question is related to elder care law. The question is, my father is getting on in years and I have questions about safety, his as well as others. He refuses to wear hearing aids, and that means he's often unable to hear us when we yelled for him to duck before our son's flying ball almost hit him in the head. Worse still, he can't hear a car's horn blowing for him to stop. My siblings have noticed that his driving reflexes are now poor. He should stop driving. We told him, but not only he can't hear, he doesn't want to listen. What do we do legally to keep everyone involved safe? David, Jackie?
Well, I think you need to have a conversation with that person's physician and hopefully have the physician concur with their opinion that he's a danger to the road, because at a certain age I believe the registry wants some proof that there's eyesight as well.
Right.
And I guess if worse comes to worse, if the individual refuses to stop the driving, you could get a guardianship over the individual.
That would be an alternative.
Yeah, that would be an alternative.
You would hope it would be the last alternative, so that you don't get into this adversarial situation with your own parent. So if logic doesn't work and the doctor can't convince them, and oftentimes it's probably best to bring in an outside person, such as a lawyer or a doctor or somebody who can convince and talk to the person logically as to why they should make certain decisions that are tough decisions. But long and short of it, if they can't agree and you think it's that much of a danger, a guardianship is a viable alternative.
It's interesting because this question was based on someone who really is caring, and it seems that there are siblings involved and they are not on the I want to take away or do something terrible to my parents for my own best interest, but rather in the interest of safety. So it's interesting that you point out both doctor, lawyer, and having family.
Well, from a legal perspective, the interest of safety is important, because if he is a danger to himself and to those on the road, then you have quite liability if the person's permitted to drive knowing that it could be a potential hazardous situation.
Right.
If that person were in an accident, would the person who is the victim then likely take action based on the fact that that person was elderly, not able to drive or whatever? Would they use that as a reason to sue, civil or whatever?
It goes back to the same rules of liability that you'd have in any personal injury case. And you have to prove negligence, that that driver did something wrong. So, for example, if the elderly person was not at fault for the accident, the other guy went through the red light and hit him, they can't make an argument that, well, he's an old driver that shouldn't be on the road and can't hear and could have avoided the accident with quicker reflexes. If none of those things are a factor or a causal connection to how the accident happened. If they are a causal connection or a factor, then of course those are all arguments that another driver could make against you if he missed the brake and hit the accelerator, which you hear about sometimes, and that's what caused the accident. It's just negligence. It doesn't have to be because the person's older, but you certainly can make the argument is that, well, it's more likely to happen a situation where you didn't hear the horn or something. I didn't hear the siren of the ambulance passing me and cut it off.
Well, hopefully that's good, useful information for our viewers. So, today's topic about technology. It's in the news. I think most people think about the internet, and so I think that many of the questions, I guess even that I had, focused on that. But in the news, there was something, a recent article about executives worrying about the spate of insider trading arrests. Hedge fund managers and technologies are hitting people like you, the lawyers, and saying what information is safe to share. So do you have that as an issue already? And what do you say about that when both people want to have some sort of reassurance from you that they haven't done anything illegal when they've said, things are good in the technology business? How does that work?
All right, there's a couple of different things that you've raised there, and you talked about internet as one part of technology. We should also talk a little bit about cell phones and driving and texting and that
Absolutely.
type of thing. The issue that you raised with information and sharing information, emails primarily, are things that we see in discovery, in cases that we have where we're going through the evidentiary gathering stage of a lawsuit. It used to be you want to get all the contracts, all of the information that's been shared back and forth by letter between the parties. Now the big area for discovery is emails and gathering up all the email information, among other things, and how technology can impact discovery. Computers, oftentimes people think they've deleted files from computers, where you can hire an expert who can go back and recreate a lot of those files. So there's a lot of technology impact on discovery and lawsuits that have affected us already.
Not only that, especially with family court litigation, all you have to do is Google someone's name and you can get an immense amount of information. Facebook, MySpace, Twitter, you wouldn't believe the information, not just with family court. I mean, you can get a lot of information on the internet because people are putting themselves out there on a public domain, and once you do that, it's no longer private.
Actually, it raises another interesting issue, what you put out there. And I tell this to my daughters all the time, that you put something on Facebook or on the internet, and you think it's not going to be seen by people you don't want it to be seen by, but it is. And an example of that is my middle daughter was applying to be a guide at the college that she goes to. And she and a bunch of her friends applied for that job, and the people in the admissions office said, "So, do you drink while you're on campus?" And my daughter said no, and the other friend said no, and they said, "Well, we're going to hire," they hired my daughter, but they didn't hire the others because they looked at their Facebook page, and every page was pictures of them drinking on a on-campus party. And I also say you apply to colleges, the admissions people could look at that. You never know
It follows you.
what's going to follow you.
Well, following up on that then, what happens if someone is making an allegation or just saying, I know you, I think I saw you drink? That doesn't, is that really proof? If you're in a legal battle with someone and you are looking at Facebook and someone mentions that they have been drinking, that's not hard evidence. It is in writing, but someone could doctor it. It could be a blatant lie. How do you deal with that?
Right. That's absolutely true, and it would be subject to cross-examination and any other device that we have to get to the truth. Cross-examination, they say, is the greatest engine of discovering the truth. If someone's in a picture with other people in the picture, and there's a drink in their hand, and they say, but that wasn't alcohol, you could subpoena all the other people in the picture, for example, to try to get to the truth.
Go back to the old way of doing things, really.
Exactly.
I mean, it's just as if somebody writes a letter and makes a false allegation in writing would be the same thing as putting it on the internet, except it's...
Technology is one more
Yeah,
layer
yes.
of information that's out there that you have to work your way through, so to speak.
Knowing that so many people rely on electronic data, so to speak, it's very easy for that information to be altered, whether it was photo or whatever. I would imagine that for forensics, that has got to be a field day. Not to mention, even for law firms who must spend an inordinate amount of time just chasing that down, potentially.
It raises, again, a few different issues. There is a burgeoning or new industry of people who are technology experts that can go out and tell you whether, just like the old handwriting experts. You know, you could look at a letter, was it somebody's signature or wasn't it? Did they write it in their own hand? Well, there's technology experts who can go back out and tell you whether something's been doctored, photoshopped, or all of that. And on the other aspect of what you asked, the technology has just created a whole new flow of information, and it raises a number of other issues that you were just mentioning about how it impacts us. I've had a case where I was involved where there had to be close to 10,000 emails for us to go through, and it involved a lawyer suing a client over a fee, whether or not he was entitled to it. And we had to go through each and every email to see, because it all impacted on whether